firm represents a lot of people who are charged with sexual assault, domestic assault, and those type of charges where the evidence that the Crown brings forth is often based on the victim's word alone. There's no DNA evidence, there's no confirming evidence, and there's no other evidence. And sometimes these are historical charges going back 10, 20, 30 years. And my clients ask me, Mike, how can they possibly charge me based on the word of a person from 30 years ago? Well, unfortunately, that's how our system works. The police they can and do lay charges based on word alone. If a victim meets with the police and gives them a video statement and the police find that the evidence is credible and reliable, they have reasonable probable grounds to lay a charge and they're entitled to do that. So the short answer is this happens all the time. People get convicted all the time just based on someone's word. However, the system's set up to favor the accused. There's a presumption of innocence. There's a WD test. So you're entitled to defend yourself, whether that's through cross-examination or you testifying as well, or a combination of the two. In another video, I talk about how those tests are applied and how it's set up in your favor. So even though it's your word against the other person's word, the system's tilted in your favor that the Crown has to prove it beyond a reasonable doubt. That is why you can often, very often, in fact, the majority of cases where it's one word against the other, you can win most of those cases in the hands of a good lawyer.